he has a passion for sharing his knowledge amongst people on different platforms. We requested him to give the insights on the topic of law relating to investigation with special emphasis on section 156 of the CRPC. As we all know that the police officers have the power to investigate the cognizable offences. But what are the ways forward in this regard? Without taking much time, I would request Mr. Budhial to take over. We all know that he has a busy schedule since he's also heading the permanent bench of the service tribunal in Bangalore. And he's a former judge of Karnataka High Court. His way of expression and juxtaposed with the knowledge has his own style, which is one of the reasons that his webinars are popular. Over to you, sir.
Thank you, sir. Thanks. Respected brother Vikas brother and another respected brother Trivikram and all my brother and sisters participants in this webinar. The topic for our today's discussion is investigation, which comes under section 156 of the Criminal Procedure Code. You know that the definition of the term investigation is defined under section 2 clause H of the Criminal Procedure Code. What is the definition of the term investigation? Is investigation includes all the proceedings under this code for the purpose of collection of evidence by the police officer or by any other officer other than the magistrate who is authorized in this behalf. This is the definition of the term investigation under section 2 clause H of the Criminal Procedure Code. And when you say that it is by the police officer for the purpose of collecting the evidence in a case, then what are the steps or the proceedings they are going to be taken place by the investigating officer or the police officer or any other officer specially authorized in that behalf is that, you know, when you receive the information about the commission of offense, of a cognizable offense, then what happens? Firstly, that under section 154 of the CRPC, they have to reduce the information into writing, and if it is a complaint given, then they have to take this complaint and immediately they have to proceed to the spot. Firstly, they have to immediately proceed to the spot, and in the spot they have to do their exercise, because what happens now, time factor is very, very important in this case so far as the criminal investigations are concerned, and I will come to that aspect, how the time is very, very important and how the investigations are going to be conducted immediately after the incident is over, because the police officers will be in a better position to collect the relevant material because it was available at the spot itself. If there is any delay, what happens now? There is a possibility of falsification of the things by both the accused as well as the prosecution. Therefore, always it is advisable to the police that immediately first they must be rushed to the spot where the incident alleged to have taken place. For example, suppose there is an incident that has taken place of the death by burns of a wife, and in that case, if you delay the things, it has taken place in a dwelling house. Suppose it is because of the flame of the stove, it has erupted to the sari of this lady, and because of the flame, then there is the burns, and subsequently the lady who sustained the burns, she expired. This is the incident that has taken place wherein the the officers are supposed to conduct the investigation. If that is the case, if they immediately rush to the spot and they are in a better position to know how the things in a place of incident, they are scattered here and there, what is the position of each of the articles. Suppose if this has taken place in a kitchen portion, or if it has taken place in some other halls of the house. Now, police, they after going to the spot immediately, they will collect the relevant material and it will be easy for them. There, all the articles which were lying on the floor of the house, and the position of the stove is very, very important, because On the basis of these material collected, one has to infer whether the allegations made in the complaint is it possible or not. Therefore, in that way, first and foremost thing for the investigation officer is immediately rush to the spot, and there he has to do the exercise. Exercise in the sense, even this conducting investigation under section 156, and if the matter is referred by the magistrate by an order under section 156 subclass 3 of the criminal procedure code is concerned, whenever a complaint is filed before the honorable magistrate, because you know that for the honorable magistrate in such thing, when the complaint is made, two options are available to the magistrate. One is the magistrate, after taking cognizance, recording the evidence of the complainant as well as the witnesses, that he can proceed in the matter under section 202 by issuing the process to the parties. And the law is very clear that once the magistrate has taken cognizance of the offense, then he cannot refer the matter to the police under section 156 subclass 3 of the criminal procedure code is concerned. Therefore, before taking cognizance of the offense, the magistrate, after receipt of the complaint or an application, it need not be the by way of complaint only. If the person files an application under section 156 subclass 3, making a request to the honorable magistrate that the case may be referred to the police for investigation, the learned magistrate, that without the taking cognizance at that stage itself, he can refer the matter by passing an order under section 156 subclass 3 of the code of criminal procedure is concerned. But here there are judgments of the honorable apex court. What their lordships have said, magistrate cannot be a post office simply to accept the application, whatever form it may be, whatever the averments that is made in the application, and simply referring the matter for investigation to the police under section 156 subclass 3 is concerned. Therefore, their lordships of the honorable apex court made it very clear that even at that stage, for referring the matter for investigation under section 156 subclass 3 is concerned, there should be a mental application by the magistrate to the available facts of the case, at least to see whether there is a prima facie material for reference. I am not speaking taking cognizance. Magistrate simply applied his mind, applying his mind not for the purpose of taking cognizance, but applying the mind only for purpose of making out a case, whether it makes out a prima facie case, at least for the referencing the matter to the police under section 156 subclass 3 is concerned. This is what mandated by the lordships of the honorable apex court in many of the decisions. Therefore, in such an incident, if the police officer immediately rushes to the spot, then he starts his investigation process, and this investigation process will continue till filing of the final report under section 173 subclass 2 of the CRPC. So if you rush to the house, as the example that we have taken in a burn case, there what happens now, the type of the burns, the injury sustained on the body, because immediately the police officer can conduct inquest panchanama also, which is also most relevant for the purpose of knowing what are the external injuries on the body of the deceased because of the burns, and the situation of the things at the place of the incident. Then the materials the magistrate, the investigation officer can collect, even he can seize the stove, the position he can record in the spot panchanama, because they are drawing a spot panchanama immediately after rushing to the spot. The contents of the spot panchanama is also very, very important for the purpose of the proceedings and the trial is concerned. Therefore, this investigation, it includes even search and seizure, arrest of the person, and collecting the evidence at the spot. These are all coming within the sphere of the term investigation, because while referring to the definition clause under section 2 clause H of the CRPC, I have made it very clear that it starts how the words are very important. It need not say, it defines, nowhere it is said. It starts with the word investigation includes all the proceedings for the purpose of collection evidence by the police officer or any other person other than the magistrate he is personally authorized by the magistrate in this behalf. This is the definition part of the investigation chapter under section 2 clause H of the criminal procedure code is concerned. Now we have to see first, we have to make it clear, when such a complaint is filed or an application is filed under section 156 subclass 3 of the criminal procedure code, making a request before the learned magistrate. Here, the learned magistrate is not bound by simply because an application is filed necessarily that it should be referred to the police. No, not necessary. It is all depends upon the discretionary powers of the magistrate. The learned magistrate can apply his mind and make out whether it is a case fit for reference under section 156 subclass 3 of the CRPC is concerned or not. Then if he founds the satisfactory that there is a prima facie material, then the magistrate can refer the matter to the police concerned police station officer to conduct the investigation in that matter. Suppose if the things are very simple, whatever in the application under 156 subclass 3 or even by way of the filing the complaint before the magistrate, if the issue involved is very, very simple, in that case, the learned magistrate, he can take a decision. It is a very simple case. Why unnecessarily the matter is to be referred to the police by passing an order under 156 subclass 3? Instead of that, the magistrate he himself can proceed in the matter. He can take cognizance of the offense, examine the complainant and the witnesses on the side of the complainant, and he can start the process under section 202 of the CRPC by issuing the next process. There are two options that I have already explained to you, and I have also made it clear. Once the magistrate has taken himself cognizance of the offense, then he need not, there is no permission, it is not permissible under the law, then he can make a reference under section 156 subclass 2 of the CRPC is concerned. This is why, because referring the matter under 156 subclass 3 is post the pre-cognizance stage. Pre-cognizance stage, wherein it will be under chapter the 12 of the Criminal Procedure Code. But once he has taken the cognizance, then he has to proceed under chapter the 15. Under chapter 15 is concerned. Therefore, this is also very important, because taking the cognizance and again he cannot fall back for the pre-cognizance stage. This is with regard to the legal position. Keeping this aspect in mind, now we have to proceed in the matter and we have to make reference to so many facets of this, the subject for discussion. Very, very important topic for the day-to-day practitioners, even for the judicial officers, the more particularly the magistrate courts, wherein this power is going to be exercised by the learned magistrate, that's the metropolitan magistrate, as well as the JMFC first class or even JMFC second class with the special authorization by the state government. These are going to be exercised by the persons. Now, important aspects are concerned that we have to make the reference one by one. Now, the first question is whether this power of referring the matter for investigation under section 156 subclass 3 can it be exercised by the executive magistrate? First aspect. So regarding this aspect is concerned, Supreme Court said no, executive magistrate is not authorized to make such the order for investigation under section 156 subclass 3. It is only the power exercised by the judicial magistrate of the first class or the metropolitan magistrate. Executive magistrate, he is not having such an authority. He may be having an authority on the matter under inquiry before him. That may be a matter pending before him for inquiry and he may be having a jurisdiction, but that itself will not authorize the executive magistrate to pass the order under section 156 subclass 3 of the CRPC. Then in that case, what is the course left open to the magistrate? At the most, he himself can be the complainant. The executive magistrate can lodge the complaint. First information he can lodge. By this way, he can set the criminal law into motion. Or else, if not the executive magistrate, the complainant before the executive magistrate, they have to lodge the information before the judicial magistrate, and they can approach the concerned police station by filing a complaint, lodging the first information. This is the option left open, but as per the judgments of the Honorable Apex Court, that the executive magistrate is not at all having the power, or the subdivisional magistrate is not having the power on the executive side to pass such an order under section 156 subclass 3 of the Criminal Procedure Code. This is one aspect. Now, secondly, with regards to what is the nature of this right of conducting investigation by the police officers, whether they can file the final report under section 173 subclass 2 of the CRPC at their whims and fancies, taking so much of time. No doubt, Under section 167, there is a time limit is there. You know that under section 167 subclass 1 is concerned, if immediately after the arrest of the accused person, if the police officer is of the opinion that the investigation cannot be concluded within 24 hours, then 167 subclass 1, what it says, immediately and within 24 hours, the accused person has to be produced before the concerned magistrate. Here, the 24 hours is excluding the time taken for journey, taking the accused person from the place of arrest and taking him before the magistrate court. This the time consuming for travel, this is excluded for the purpose of calculation of the time of 24 hours. And 167 subclass 2, this is also we have already made reference in our previous lecture, that while making a reference to the statutory bail, that you have already, the bail lecture you have already heard by some lecturers. And in this case, 167 subclass 2, what happens now in a heinous cases that you know, if the offense is punishable with the punishment of more than 10 years, life imprisonment or capital punishment, under such circumstances, the time for completing investigation and filing the final report is 90 days time. And so far as other lesser offenses, lesser severe offenses are concerned, it is 60 days. If the investigation is not completed within that time, it gives a statutory right to the accused person to apply for statutory bail. That is, we are concerned with the bail aspect, that is different. But investigation is concerned, you see, in many cases, what happens now, the time taken by the investigating officers are, you cannot believe, more than 2 years, more than 3 years. Like this, the police officers, they are not prepared to file the final report for one or the other reason. We don't know. There are so many reasons for that. According to the police, they may be having some complications or difficulties. And because of this reason, what happens now, the Honorable Supreme Court recently, a division bench of the Honorable Supreme Court, in one case, that is a case from Punjab, it is a Jat agitation by the people belonging to Jat community, and the accused persons, they were arrested. And one of the person that he went up to the Supreme Court in that particular case, he is seeking that the investigation is not concluded in spite that I have been in custody for more than a period of 2 years. That was his grievance. And in that case, there is a division bench decision of Honorable Justice Adarsh Kumar Goyal and Honorable Justice Indu Malhotra. Recently, the judgment has been delivered by the Honorable Supreme Court. What their lordships have gave the direction in that particular case is, because of this reason, because you see, when a person's the investigation is not completed for such a long time, directly it affects his fundamental right of Article 21, that every accused person has got the right that he can get the speedy disposal of the case. And Supreme Court also made it clear, it is not only the trial proceedings that the fundamental right under Article 21 is made applicable, even it precedes the earlier stage also, that is the investigation. Now the position is very clear. Speedy disposal of the case doesn't mean that the investigation can be delayed at any length of time. The Supreme Court said even it applies to the fundamental right under Article 21, it also going to affect if the investigating machinery are not completing the investigation and taking the longer period of time to complete the investigation and filing the final report. Therefore, their lordships, what they have given the direction that the central government was directed, you call the investigating agencies of the central government as well as the state governments, convene the meeting of all these investigating agencies. We can have the in-house mechanism for this. In-house mechanism, and we can discuss this problem in the in-house, and what is coming out, a committee is going to be constituted by the central government in this regard for the purpose of framing the guidelines, how the investigating officers, depending upon the nature of the offences in each and every case, how they have to attend the investigation and within what time they have to conclude the investigation. This is what their lordships have given the direction, and whatever the committee report, then their lordships have given actually the further date for the purpose of submitting that report. On the basis of that report, the Honorable Supreme Court is going to pass some other orders But the direction in that particular case is for conducting the investigation immediately, concluding the investigation immediately, not to delay the things, because it is also affecting the fundamental right of an accused person for getting the speedy disposal of the cases is concerned, and so also getting concluded the investigation within a short period of time, within a reasonable period of time. In that particular case, I have brought to your kind notice, though the time of arrest, it has been elapsed for a period of more than 2 years, that person, he was in the jail itself. That was how it speaks on the very system of the investigation. Of course, there is the provision under the CRPC that the police are having their own power under section 154 to register a case whenever there is a information with regard to the commission of a cognizable offense. Then they can proceed to conduct the investigation invoking section 156. The officer in charge of the police station, he can proceed to conduct the investigation. And there are also judgments of the apex court as well as many of the high courts that when the investigation process is going on, the high court as well as the Supreme Court unnecessarily, they should not interfere into the investigation process by passing the orders by under the writ jurisdiction or under section 482 of the CRPC. But wherever it is necessary, when their lordships feel it is necessary that to give some direction under such exceptional circumstances, the court can interfere into the process of the investigation. That is permissible under the law. Now we have seen that in many cases the investigation is not going to be completed. It is unnecessarily going to be delayed, which is affecting the rights of the accused persons. Therefore, Supreme Court has taken care by issuing such a direction in a recent decision by the division bench of the Honorable Apex Court. This is with regard to the time spare, how the investigations are to be regulated by a time factor, how the investigation is to be completed is one of the aspects. Now, the next aspect we wanted to touch is with regard to defective investigations going to be conducted by the police and filing the final report. Defective investigations, whether it is because of the intentional act or the malified, or it is because of that the materials were not available and they were helpless in the matter, we don't know. But we have to, the court has to examine each and every case, and then the court has to come to the conclusion. And so far as the defective investigation is concerned, the question that will arise for our consideration is, if the investigation seems to be defective in nature, whether it will give a right to the accused person that he is entitled for acquittal, is the point. Very important aspect. Because what happens now, if you say that because of the defective investigation, it will give a right to the accused person for getting acquittal in the matter, then you see the dangerous thing that is going to happen. It will take away the supremacy of the court's orders, because ultimately the findings are the conclusions arrived at by the investigation officer in the investigations, that becomes final. Such things should not happen. Therefore, regarding this aspect, the Supreme Court made it very clear in many or plethora of the judgments. We can make a reference to one such a case. I have taken one particular case, and we can make in detailed reference how this defective investigation automatically will not give a right to the accused person for acquittal unless and until he has to show that because of such a defective investigation by the police, how his interest is going to be affected, how there is a bias, how there is a prejudicial to the interest of the accused person. Unless and until he is going to establish, there is no process of automatic acquittal of the accused person because of the defective investigation by the police machinery. You know that sometimes the police, not in all cases, but at least in few cases, purposely they may deviate from the regular, the manner in which the investigation is to be conducted. Purposely they may delay the things. And if we discuss that the one particular reported judgment, it becomes very clear for you, and how the Honorable Supreme Court came very heavily on the investigation officer. The one case that is it is the case that is in the year, you can have the citation AIR 2001 SC, page number 142. AIR AIR 2001 SC, page number 142. The parties in the case is State of UP versus Hari Mohan and others. This is the case. And the relevant paragraph in that particular case, judgment is para number 9, wherein their lordships have made severe comments on the investigation machinery in that particular case because of the defective investigation. There what happens, the factual matrix involved in that particular reported decision, a married lady, that he was sent to her husband's house 2 months earlier to the fateful incident. This lady, she died because of the gunshot injuries, and her body, it was tied and it was wrapped in a bed sheet. Then the body was thrown into the water tank. And subsequently, what happens now, when the investigation that was going on, the investigation officer collected one letter which this deceased addressed to her parents. What are the contents of that letter? She made it that you please come and take me to my parents' house. Otherwise, that it is not possible for me. The in-laws and the husband and the brother-in-law, they are all going to kill me. These are the contents of that particular letter addressed to their parents. That letter was seized by the investigation officer. Of course, in the letter, what happens now regarding the date is concerned, there is the erosion and some correction was there in the letter. And subsequently, what happens now, the parents, they came to the house of her in-laws, and they have discussed where is the lady, and they said that she died because of the cholera. That was the say made by the persons of the in-laws house. Then investigation went on. Then this accused number 1, Hari Mohan, who is brother of her husband, he was having a license to possess a gun. The license was there in his name, and it was valid also at the date of the incident. Then the rifle was seized, the gun was seized, and during investigation, though this exercise that was made, but what has happened in this case is the gun was not referred to the ballistic experts by the investigation officer, though it is actually seized under the Panchnama before the punch witnesses. He kept himself without referring to this gun to the ballistic experts. The very charge is that you have committed the murder of this lady by gunshot injuries. In spite of that, the investigation officer, it is not his case that the gun was not available in spite of my best efforts made during the investigation. He seized this gun, even then not referred. The reference of this gun is to the ballistic expertise. For what purpose? To know whether these bullets, they have been discharged from the barrel of this particular gun. This is the object of referring the material object to the ballistic experts are concerned. These things, they were not done. But during the course of the trial, before the trial judge is concerned, even the trial judge in his judgment made a reference in one paragraph. The investigation officer is a most negligent fellow. He has not handled the case with proper care. These are all the observations because the Supreme Court in its judgment also make a reference that the learned child, the trial judge has already made reference about the faulty investigation conducted by the investigation officer. Their lordships have said that why this matter come up before the Honorable Supreme Court is trial judge somehow convicted the accused. This accused number 1, Hari Mohan, was convicted for 302 for committing a murder of gunshot injuries. All others, the husband of that lady and the in-laws and other family members, they were convicted for the offense under section 201 for screening the evidence in the case. And ultimately what happens now, the matter was taken before the Honorable High Court. Honorable High Court, examining these defects in the investigation, that the letter, it was not referred to the handwriting expert to know whether it is in the handwriting of the deceased or not, and making an observation with regard to non-referring this gun also to the ballistic expert, ultimately they allowed the criminal appeal and set aside the judgment of the conviction and acquitted all the accused persons. Then the state of UP preferred the appeal before the Honorable Supreme Court. This is with regard to the factual matrix involved in that particular case is concerned. Their lordship said that so far as this possessing of the gun by accused number one, the Hari Mohan, who is the brother of the husband of the deceased, it is not in dispute. It was standing in his name, which was valid also on the date of this incident. And there is one witness, PW3, who has been examined before the trial court. He said, and his statement was recorded, what he said before the investigating officer under section 161, the CRPC. I heard the huge sound firing in the house of this Hari Mohan on that particular morning. But even for this, Supreme Court has clearly observed what is his say before arguing the case before the Honorable Supreme Court. No doubt I have fire. It was an empty fire in the air. That was the contention taken by accused number one, Hari Mohan, before the Honorable Supreme Court. Then there is another witness, PW4, the own brother of this deceased, who has been examined so far as the handwriting, identifying the handwriting of this deceased. His sister, that PW4 is the own brother of that deceased lady. Then he identified the handwritings. Therefore, the Supreme Court said, when there is a material to prove the identity that the handwritings are from the very deceased herself, then it is not for the prosecution to refer the matter to handwriting experts to know. But on the contrary, it is for the accused person. It was he who could have made an application seeking a reference of this letter, contents of this letter, disputed letter with the admitted handwritings. No such a request was made by this accused person before the trial court. Therefore, the fault is on the part of the accused. And when then the Supreme Court said, in spite of such a defective investigation that was conducted by the inquiry officer, even then the gun was not referred for ballistic expert, but looking to the material collected during the trial proceedings is concerned, it is making out a very the acceptable case on the side of the prosecution. Therefore, the learned trial judge has rightly come to the conclusion in basing the conviction, but the High Court has completely ignored this aspect and wrongly proceeded in the matter, allowing the criminal appeal and the passing the judgment of acquittal. This is all with regard. But in para number 9, you please read that judgment very beautifully, that has been written by the Honorable Apex Court. Their lordships have gone to the extent we could have written for taking action against the investigation officer, but we are helpless. By this time, the investigation officer may not be in service. These are the words of the Honorable Supreme Court in that particular judgment is concerned. Therefore, this one judgment is made us very clear that simply because there is a defective investigation, that itself ipso facto not sufficient for the court to come to the conclusion that it is the accused is entitled for the acquittal. It is all the matter for appreciation before the court, even in spite of the investigation material. But what is tendered, evidence tendered by the witnesses before the court is sufficient, then the Supreme Court said you can rely upon such evidence. You just ignore the investigation material. That is permissible under the law. So this is the one of the another important facet of the investigation chapter regarding the defective investigation or wrong investigation is concerned, which is not the ipso facto or automatically giving a right to the accused person for his acquittal. But if the defective investigation is there, and even looking to the evidence recorded in the case is concerned, suppose if the Honorable Court is of the opinion that there is no proof of this charge beyond reasonable doubt, then in that case helpless, nothing can be done. But if the material is there, sufficient material is adduced by the mouth of the witnesses before the judge, because it is on oath and the witnesses are subject to cross-examination by the defense, and when acceptable evidence, the cogent and acceptable material is placed before the trial court, it is sufficient, and accused on that ground not entitled for acquittal is one of the another important aspect that we have discussed about this investigation chapter. Now come to the another aspect of the matter with regards to the investigation chapter. Now it has been elaborately discussed by the Honorable Supreme Court in the Constitution Bench judgment recently that was rendered, that the facts of the case that they were discussed in the Constitution Bench judgment is concerned. Court has taken into consideration many of the judgments on both the sides. There was a argument on both the sides before the Honorable Supreme Court, so far as the law is concerned, which is made in the full bench judgment, that I will make a reference to the citation of that particular judgment of the Constitution bench. You please note this: 2020 10 SCC, page number 120. It is in the case of Mukesh Singh versus State Narcotic Branch of Delhi. In this particular case, suppose the informant, he himself is the investigation officer. What will happen? Informant, he himself is the investigation officer, means he is the complainant as well as he is the investigation officer. Whether the proceedings are going to be vitiated or the proceedings are not going to be vitiated is the point that was agitated before the Honorable Supreme Court before in this the Constitution bench judgment is concerned. Here what has happened now, in earlier judgments, I can refer to the many judgments of both the sides which the Honorable Supreme Court has made a reference. In the Bhagwan Singh, Megha Singh, and one more another judgment is there. In that, the reference made by the Honorable Supreme Court in that when the learned counsel, senior counsels were arguing before the Honorable Supreme Court, wherein the Honorable Supreme Court held that if the informant himself is an investigation officer, the whole investigation proceedings are vitiated and accused is entitled for acquittal is one of the argument that was canvassed before the Honorable Supreme Court. In the year 2018, there is one more important judgment, that is Mohanlal versus State of Punjab. Mohanlal versus State of Punjab is in there 2018 before the Honorable Supreme Court itself, wherein it has been held that if the investigation officer himself is the complainant, then in that case what happens now, it is a biased investigation. It will prejudice the interest of the accused person, because the nature of the human beings, naturally what happens now, when a person filed the complaint, always he wants that the investigation material he wanted to collect in support of his the complaint. Therefore, he will make the exercise in that fashion, and it is directly going to prejudice the interest of the accused person. That was held in Mohanlal's case, in Mohanlal versus State of Punjab in their 2018. But in 2020, there is one more judgment, Varindra Kumar. This is also before the full bench of the Honorable Supreme Court. But in Varindra Kumar, the full bench made it very clear, referring to Mohanlal's case is concerned, what the lordships have laid down the proposition in that Varindra Kumar's case is concerned, that if the informant himself is the investigation officer and as ruled in a Mohanlal's case, but it is having a prospective effect, but it is not having the effect so far as the pending matters in the before the trial court or before the appellate court. It is not made applicable or to the earlier proceedings. Prospective effect is there. This is ruled in a Varindra Kumar's case by the Honorable Apex Court. Therefore, because of such a judgments on both the sides, because there are another set of judgments on the side of the prosecution, and the Honorable Supreme Court also held in a series of decisions. No, if the informant himself is the investigator in a case, automatically it cannot be said that the whole proceedings are going to be vitiated. The court has to examine this aspect of the principle on case-to-case basis. You have to examine on the case-to-case basis and take a decision in the matter. And it cannot be said that it is laying down an absolute rule, general rule applicable to all the pending cases or even the cases coming before the courts in future. This was the observation in many of the other sets of the decisions. Because of such variance in the judgments of the Honorable Supreme Court itself on both the sides, ultimately what happens now? Firstly, the matter was referred to three-judge bench, but the three-judge bench passed an order. No, the matter requires that it is to be decided by a larger bench. Therefore, the five-judge bench, the judgment is rendered in 2020. I have given the citation 2020-10 SCC 120 in the case of Mukesh Singh versus State Narcotic Branch of Delhi. In this particular case, their lordships made the very elaborate discussion about these principles and the earlier judgments of the Supreme Court itself. And His Lordship Justice M R Shah has wrote the judgment in this, the Constitution bench judgment, and all the points were elaborately discussed. Why the Supreme Court laid down such a proposition in the earlier case, in Bhagwan Singh's case, Mega Singh's case? Their lordships have said that in that particular case, the factual story involved and the investigation conducted, it was in that fashion. That was the reason for laying down such a proposition. In one case, that is the Bhagwan Singh's case is concerned, accused, he was involved in a smuggling of a food grains. And when he was caught by the police, he offered a bribe of rupees 510 to the police officer. And because of that reason, the police officer arrested him and a case was booked. And the police officer, that is, he conducted investigation and registered the FIR as head constable in that case. Then the investigation concluded and he himself filed the charge sheet. The Honorable Supreme Court said that in that particular case, there are no other important witnesses at all. The head constable himself is the important witness because it has happened to him. And immediately that he has registered FIR and he conducted the investigation in the matter. Therefore, when there are no other witnesses at all, the court laid down the proposition that there are no other independent witnesses examined in this case. The case rests only on the person who gave the information and subsequently he proceeded to conduct the investigation. Therefore, the investigation is vitiated and therefore it cannot be made use against the accused person. That was the principle laid down in that particular case. And in the subsequent case, Mega Singh's case is concerned, that here also the police, the head constable who conducted the investigation, that he caught one person who was possessing a country pistol with live cartridges. And he was caught by head constable. Immediately the head constable, he himself registered the information, first information, and he conducted the investigation in the matter. Supreme Court said, where are the other witnesses? He himself, that he proceeded in the matter. These are the factual metrics which were taken into consideration by the Honorable Apex Court and laid down such a proposition. Therefore, it cannot be said that the principle is said to be the generally applicable to all other cases. Therefore, after assessing thoroughly with reference to all the earlier judgments, the Constitution bench of the Honorable Supreme Court recently in 2020 laid down the proposition that always it is to be examined on case-to-case basis. Case-to-case basis, after examination, if the court is of the opinion that because this informant, he himself proceeded as an investigation officer in the matter, the whole proceedings are going to be vitiated. If that is the opinion of the Honorable Supreme Court, all right, in that particular case, you can rule like that. But if the investigation officer and the informant is one and the same person, but looking to the other material and evidence collected in that, if the other material is independent material, going to prove the charge independently, even leaving aside this evidence of informant who is an investigation officer, Supreme Court said there is nothing wrong in basing conviction of an accused person. Because the Honorable Supreme Court said, no doubt, individual rights is undoubtedly, it is to be looked into and it is to be protected because it is touching to Article 21 of the Constitution of India. But the Supreme Court also observed in that decision very interestingly that at the same time you have to see the societal interest also. And this person, accused person, only taking this banner that the informant, he himself proceeded to conduct the investigation, he cannot have such a situation and get his acquittal from the case. Supreme Court said, we have to give importance to the societal interest also. Therefore, both sides is to be taken into consideration. It is not only the interest of the accused, but the victim side is also to be looked into. When after assessing the entire material, if the court is really of the opinion that because this informant continued as an investigation officer, really it affects the whole case and the whole case is going to be prejudiced, then you can acquit the accused person. But Supreme Court said that cannot be absolute rule in all the cases. Therefore, the reason is you can examine the matters by case-to-case basis. Then you can take a decision in the matter. In any particular case, if there is a material available, excluding this investigation, the investigator or the informant, other material is inspiring the confidence of the court that really such accused has committed the offense, then there is nothing wrong in relying upon such evidence and basing the conviction. Therefore, that cannot become the absolute rule is one of the important judgment of the Constitutional Bench recently delivered so far as whether the informant can continue as the investigation officer. The court has also made a reference to so many provisions of the NDPS Act also. NDPS Act, the reference is made in this Constitution Bench judgment. I am making reference because under the provisions of the NDPS, what happens now? Section 41, Section 42, 43, 44, court has made a reference that there are some authorized officers to go to the spot immediately because NDPS, you know that some credible information is going to be received by the officer. If such information is not immediately attended to, then there is a chances of disappearing the entire material. The narcotic drugs possessed by the persons, if immediately they were not arrested and this narcotic drug is not seized from their possession, then there is nothing in the investigation at all. Therefore, the persons who are authorized under these 4 sections, they are immediately rushing to the spot. They were drawing a spot mahazar. They were seizing the material, the contraband, the narcotic drugs in possession of that particular accused person. They are arresting that person. Ultimately, all they were bringing to the police station, and after coming to the police station, the authorized officer who has done all these things, he will lodge a complaint, first FIR in the police station. Thereafterwards, what happens now? Under Section 53 of the NDPS Act, the another officer that who has taken all this material into the charge, he will start the investigation into the matter, the remaining part of the investigation. Therefore, the Supreme Court laid down the proposition so far as reference to the NDPS Act provisions are concerned. There are safeguards in the NDPS Act itself. Section 58 of the NDPS Act, what it says, if the investigation officer that has the purposely that he has they conducted such a he created such false material and the faulty investigation or faulty seizure of the if that is there, then he is liable for the punishment. It is a cognizable offense. Section 58 of the NDPS Act is very clear. Then the Supreme Court says, when the lawyer arguing before the Honorable Supreme Court that these are the things going to happen and prejudice the interest of the accused person, and it is going to be a biased one, the Honorable Supreme Court, the judges in this very Constitution Bench judgment, their lordship made it very clear. In the very enactment NDPS Act itself, there are safeguards that were taken. That Section 58 is a very the important provision. It is against the person who is doing all these things, arresting and immediately rushing to the spot and effecting the seizure mahazar. If there is something the faulty and it is with malafide intention, then it amounts to cognizable offense against the very officer himself, and action can be taken. When such a safeguard is there, where is the question that the interest of the accused is going to be biased or it is prejudicing the interest of the accused person? Therefore, the Honorable Supreme Court very clearly made it very there in that particular judgment that no such things will happen, and in spite of that, the interest of the accused is going to be will not going to be affected, is the finding recorded in that particular judgment is concerned. And so far as the reverse burden is concerned, in the NDPS Act, you know that in other acts also there are reverse burden principle. Reverse burden principle. It was also argued because the act is very serious. There is a reverse burden on the accused person himself, because Section 54 and Section 35 of the NDPS Act, you please remember. Section 54, what it says, if any narcotic drugs at the controlled article that has been seized from the possession of the accused person, a presumption is in favor of the prosecution, and the burden is upon the accused person that he has to disprove that presumption, he has to rebut that presumption. But presumption is in favor of the prosecution. That is Section 54. Whenever the narcotic drugs or any controlled article that has been seized from the possession of the accused person, immediately the presumption under Section 54 of the NDPS Act comes into the play. That is a reverse burden. And what about 35 of the NDPS Act? Section 35, it also presumes that whenever such things are there, then it refers to the mental condition that it is intentionally that accused person he was possessing. That is also one of the presumption under Section 35. Therefore, the accused has to discharge the burden or he has to revert the burden. This was one of the points that was canvassed before the Honorable Supreme Court. When such a thing is there, then the investigation, if it is not properly conducted by the officer, then it affects the interest of the accused person is also one of the points that was canvassed. And so far as the principle of reverse burden is concerned, you are also seeing under the Prevention of Corruption Act. Under the Prevention of Corruption Act, suppose if the trap is laid against the person who is receiving a bribe amount, and the tainted currency notes that has been recovered from the possession of the accused person, then in that case, what happens now? Section 20 subclass 1 of the NDPS Act will come into play, that it presumes that he has committed that offense, and it is for the accused person to rebut the presumption. So also such a presumption, even under the IPC, the offenses also you have seen under section 304 capital B in dowry death cases. In the dowry death cases, if the prosecution established two things, the death has taken place within a period of 7 years from the date of the marriage, and immediately prior to her death, she was subjected to the cruel treatment in view of the dowry. If these two things were established, immediately the presumption comes into operation that it is a dowry death case. And the burden is on the part of the accused person. It is called a reverse burden. And the accused person has to rebut, the burden is on the accused person. Therefore, this will have to be taken into consideration by the courts of law whenever they are dealing with the informant himself is the continued at the investigation officer and collected material, file the charge sheet. The court has to analyze all these things by case to case basis, and then only the court has to take the decision. But it is not an absolute rule, made it very clear. This is another aspect that we have made the reference so far as the investigation officer, he himself, they are proceeding in the matter to conduct the investigation and filing the charge sheet. Now coming to the other aspect of this investigation chapter, we made a reference that the magistrate can refer the matter under section 156 of class 3. But even if the magistrate has not referred the matter under section 156 of class 3, but under section 156, it is the bounden duty of the police officer in charge of the police station that after the receipt of the information, immediately that he has to proceed in the matter for conducting the investigation, and he has to file the charge sheet. That power is always there. 156 section, it deals with the power of the police officer in charge of any particular police station. Even otherwise also, not only under section 156 of class 3, whenever there is a direction from the magistrate court, you proceed with the investigation of this particular case. Not need necessarily. If there is a direction, all right, the police will have to obey it. They need not the content, like any other contentions that it cannot be done. No such contentions. It is a mandate by the order of the learned magistrate. They have to proceed with the investigation in the matter, and they have to ultimately file the charge sheet. Whenever the charge sheet is filed, you know that under section 173 subclass 2, if there is a B false report, mistake of fact, if such a charge sheet is filed, then it is a well-established practice by the judgments of the Honorable Apex Court and many of the High Courts that the complainant must be given an opportunity to submit his protest memo. Immediately, after filing the charge sheet that there is no case at all, the magistrate cannot close the matter. Opportunity is to be given to him. And after giving an opportunity, if the complainant filed the protest memo, still he contends that no, there is a material, but the investigation that was not conducted properly, then in that case, what happens now? The court has to examine the complainant and his witnesses, and after examining the witnesses and the complainant, if it is making out a prima facie case, and in that case, the magistrate can take the cognizance in spite of the fact that the charge sheet has been filed by the investigating machinery, that there is no case not made out at all. This is also one of the another important the principle under the chapter under section 156. Now the question is, law is there that investigation is to be fairly conducted, immediately it is to be attended, immediately the charge sheet is to be filed, the final report is to be filed. All these safeguards are there under the law. But question is, practically what happens? You all know the things are happening in such a way that nobody can anticipate that such a report is going to be filed by the police in any particular case is concerned. Therefore, the Honorable Supreme Court, in one case, they have made it very clear. It is not only the duty of the investigating machinery that always they must be anxious to collect the material so as to impose the conviction on the part of the accused. No, that is not the role of the investigation machinery. What is their role is to find out the truth in the matter and to collect the unvanished material, real material. The object is the investigation machinery, they have to assist the judge in knowing the truth in the matter involved, and they must not be on one-sided, because they are considered to be very important machinery under the CRPC, the investigating machinery, that they must be prompt and honest in conducting and discharging their duties is very, very important aspect while consideration of the case by the honorable judges before the court of law. I will give an example. This has been discussed by the Honorable Supreme Court in one of the judgments that I have collected, wherein their lordships have also observed that fair investigation, prompt investigation, what do we mean by this fair and prompt investigation means? It is always the investigation officer's duty that he must collect the material which is truthful and which is in the nature of assisting the judge to know the truth in the matter. Then it will be helpful in deciding the case, otherwise no. But artificiality in the investigation is very, very important that one has to consider. Artificiality in the investigation is the destroying the many of the cases before the courts of law. If they were put naturally, exactly what has happened in the very fashion that the incident has taken place, chronologically, if the investigation machinery are conducting the investigation and filing a final report, so definitely that it will assist the court in come to a right conclusion. But things are not that. What is going to be happen is artificiality by the police. You might have seen two sections of the Indian Evidence Act, Section 25 and Section 26. What they say? Any admission or any statement made by an accused person in custody before the police, it is not admissible in evidence. This is the fundamental principle of Section 25 and 26 of the Indian Evidence Act. But what Section 27 says? Section 27 of the Evidence Act is in the nature of an exceptions to both the above sections, that is 25 and 26. Why? What is the object for that? If you say that the statement made by an accused person is totally inadmissible in all the circumstances, if that is the absolute law, then it causes very severe damage to the prosecution case. Why? Because I will give an example. If an accused person, after committing the murder, he has taken these weapons to a far distant place and he has hidden this in bush, then how the investigation officer he is expected to know that apart from this investigation place, that accused person has taken this weapon in such a far away place and he has hidden it in a bush? How can he expect? That is the reason that the lawmakers think that always the best evidence is to be brought before the court. Best evidence to be brought before the court when it is possible. If you made an exception by way of Section 27 of the Indian Evidence Act, what it says? Indian Evidence Act Section 27 is to this effect that so much of the statement of an accused person as distinctly it refers to the discovery of the information. You see, statement made by an accused person as it distinctly refers to the discovery of the information. To that extent, the statement made by an accused person is admissible in evidence. Therefore, it is in the Section 27 is in the nature of an exceptions to earlier two sections, Section 25 and 26 is concerned. But the Supreme Court made a reference in one case, what their lordships have observed. In one case, where the incident has taken place with the weapon, murder weapon, that weapon was left in the spot itself, it was lying by the dead body. But the police during investigation, what they have shown, they have seized and recovered this weapon by a far away place. That is as if they have conducted the investigation under Section 27 of the Indian Evidence Act. It may be because of they wanted to show that they made some adventures in the matter in their investigation. This is a faulty investigation, that this is a artificial investigation the police are making. This is one of the major cause that many of the prosecution cases, they will be lost before the courts of law. They are not natural. And what you see the fun? See the fun. What happens now? Suppose a spot panchanama is drawn. In the spot panchanama, that they have not mentioned that this weapon is lying by the side of the dead body. The panchas of the spot panchanama, they are supporting the case of the prosecution, but useless. Even if they supported the panchanama, that the weapon is not at all there in the spot. And this recovery panchanama at some distance hidden in the bush and under the voluntary statement of an accused person under section 27 of the Indian Evidence Act, they go there, taken the panchas, and in the presence of the panchas, the accused person, they pointed out and took out the weapon from the bush and has produced it before the police officer, and they have drawn one panchanama in the presence of panchas. You see the fun of it. Those panchas, they have not supported the case. Recovery panchas have not supported the case for the recovery of the weapon. You see the fun of it. The artificiality made by the police, it has gone to such an extent. Had they shown this weapon as it is, that naturally it was lying by the side of the dead body, the punch witness spot panchanama, they were already supported. Supreme Court has cited in one of the judgment that these are the things that is the artificiality by the police, that it is also one of the major reason that is going to destroy the case of the prosecutions before the court of law in many number of cases. Therefore, it is also one of the important principle of law that always the investigating machinery, they must think that the investigation purpose is to collect the truthful evidence, and they have to assist the court by producing such material before the court, and they should not create such, they should not planted such evidence in the during the course of the investigation. Therefore, ultimately what happens now, it all depends upon our honesty and sincerity in attending the matters. Law is there, but if I am not sincere and honest in attending, then the result will not be in my favor, because I myself is not the honest person and I am dishonest. I wanted to create something which is not at all there in the case. Artificiality I wanted to create. Therefore, this is also one of the important aspect in the subject while conducting the investigation by the police is concerned. This is all with regards to the investigation chapter under section 156 of the CRPC. And my brothers and sisters who are having any sorts of doubts, you can raise the questions. Yes, Vikas sir.
Yes, sir. In fact,
any questions, sir?
Yeah, there are questions.
Yeah.
In fact, I close the video so that there's no eye contact for your disturbance. Raghav, he says, what are the remedies of the dismissal of a protest petition in section 156, subclause 3 of CRPC, whether it is a review or an appeal?
Now, if the complaint is, the application is dismissed, it is not an interim order. It is not the interlocutory order. Under section 397 of the CRPC, revision lies to the Honorable High Court.
Mr. Rao says, can a learned magistrate go beyond the scope of section 156 subclause 3 when the prayer is expressly under section 156(3) with regard to the progress, even after taking cognizance, can direct investigation?
No, I have already told the judgments of the Supreme Court. Ordinarily, what happens now, it is the absolute, the domain of the investigation machinery when they are conducting the investigation. If the investigation they were normally conducting, there is no occasion for the High Court or even the Magistrate Court to interfere into the investigation process. But as we have already discussed, suppose there is a delay, unreasonable delay in concluding the investigation and filing the report, or some other things they were reported to the Honorable Magistrate that something that is going on. If the Honorable Magistrate feels that it is necessary to give further direction in the matter, the Magistrate is within his the power to give such a direction.
Yeah, this is. This is by Dr. Madhuka. In the petition, that is the complaint, The complainant states that the assault on him, threat to life is more than by 25 unlawful assembly, has been recorded by 3-4 persons, including Zilla Parishad. But the IO neither procures the evidence from the Zilla Parishad nor attempts to say the truth during the deposition. The victim procures the DVD through the RTI, complies section 1665B, and submits it through the prosecution through witnesses PW1 during the deposition. But the trial court rejects the document.
Sir, so far as section 65B is concerned, I can make a reference to the judgments of the Honorable Supreme Court that we can make a reference to the Parliament attack case. Parliament attack case, which was decided in the year 2005, I think. Justice P.V. Reddy, the division bench, the P.V. Reddy delivered the judgment, and that judgment is after coming into the force of the Information Technology Act in 2000. Is it correct, sir? And in that case, the electronic material, electronic evidence that was led before the court, before the Honorable Supreme Court in that case comes to the conclusion that they are admissible. And by that time, section 65B, it was already there in the Evidence Act by way of amendment. But in the year 2014, there is a full bench judgment of the Honorable Supreme Court, and Justice Kurian Joseph wrote the judgment of the full bench. His Lordship said that unless the conditions under section 65B are fulfilled, such electronic evidence is not at all admissible in evidence. That was the judgment in the full bench by the judgment of Justice Kurian Joseph. But subsequently, there is one more judgment of the division bench. The name of the party that I may not recollect. In a division bench judgment subsequently, referring to this full bench judgment of Justice Kurian Joseph, the division bench said that there cannot be absolute rule, but it all depends. Suppose the original of that electric record is not at all in the possession of the party, how the party is expected to produce such evidence?
Sir, Naveen Kumar cites that is Arjun Khottar versus Kailash Krishan Rao.
Yes, sir.
He cites the judgment which you are recollecting. He says it should be Arjun Khottar versus Kailash Krishan Rao.
No, sir. No, sir. It is some other judgment of a division bench. Their lordships have said it cannot be absolute rule as such. It depends upon the facts and circumstances of each case. Because what happens now, the law is that unless the original is produced before the court, the condition under section 65B of the Indian Evidence Act is not said to be complied with. Therefore, that material is not admissible in evidence. But their lordships in the division bench made a reference that suppose you are insisting a party to produce the original, until that the electronic record produced before the court is not at all admissible in evidence. But if the party is not at all possessing the original, then what will happen? Therefore, in spite of having this original, if the party fails to produce before the court, the adverse inference can be drawn under 114E of the Indian Evidence Act. And in that case, the admissibility cannot be allowed by the court.
Yes, sir.
The electronic records means what happens, one of the condition under 65B is that how it is generated from whom for the first time. There must be a certification by that person that it is, I hereby certified that this document is taken from the original. If in the absence of such a certification, it cannot be said that the condition under 65B is said to be complied with.
Yeah.
Therefore, sir, it all depends upon the factual story involved and the evidence and the material collected during investigation. Depending upon that, the court in each individual case, they can take the decision, and there cannot be any straitjacket formula that it can be absolute rule that the electronic records, unless they are the condition under 65 is complied with, they are not at all admissible in evidence. No such law can be laid down. I am referring to that division bench judgment, though I am not recollecting the name of the party, sir. Some Mamdan party's name that is there. Some Ahmad like this, the name is there.
There should be then Shafi Muhammad versus State of Himachal Pradesh.
Exactly, sir. Exactly.
2018, volume 2, SEC 801.
Exactly.
But thereafter, sir, that full bench judgment has come. This is on 20th November. I'm just checking it out because a lot of webinars have been done. We were also planning to do on that.
Okay, sir. But Shafi Muhammad, correct, sir. Division bench judgment.
Yes, sir.
Their lordships have made elaborately about the full bench judgment written by Justice Kurian Joseph, and their lordships have also discussed at length. And after discussing, their lordships have said that there cannot be such an absolute rule. it all depends upon what has happened in the case, particular case. What are the circumstances leading to this, the production of the electronic evidence, even for raising up the objection at that stage itself, when the document is going to be marked before the court. If it is taken during the course of trial without raising such any objection, these are all the points that the lordships have discussed in Cr.P.C. Mohammad's case, sir.
And thereafter, this three judges judgment,
Yes.
which recently came.
Yes, sir.
That is on the date of, I read it, section 65B. That is the basic judgment now, which
Correct, sir.
14th July.
Correct, sir.
This judgment is under P. No. It is on 14th July. That's what showed by 3 judges.
PV Anwar is, I think, that is Justice Kurian Joseph, sir. In 2014, PV Anwar, that is written by Justice Kurian Joseph, sir.
Yes.
Cr.P.C. Mohammed is subsequently.
No, sir. Thereafter, on 14th July 2020, during this lockdown time.
Oh, 2020. 2020.
Yes, it came on. The title is not forthcoming. I was just checking it out.
Correct.
There are a lot of webinars on that. I'm just checking it out. I will just tell the.
That's correct, sir.
It is by Justice Nariman, Justice Bhatt, and Justice Subramaniam. It was
Next.
held that the certificate required under Section 65B(4) is a condition precedent on admissibility of evidence by way of electronic evidence. And they have in fact concurred with the 3 judges judgment, which my lords you are referring, that is Anwar P. Anwar P.K. Bashir.
Correct.
2014-10.
Correct, sir. Full bench judgment.
Yes. That Naveen Kumar also says that Arjun Khatkar has overruled Shafi Mohammed.
Yeah.
And so thank you to all the friends who have been connected with us for all these webinars. And tomorrow we would be having remedies against the police excesses, wrongful detention and custodial deaths, with special reference to law of torts by Justice D.V.S. Somalaraju, Judge, Andhra Pradesh High Court. Do stay connected with us tomorrow at 5 p.m. Everyone stay safe, stay blessed. And thank you, sir, once again. It was an engaging session and it gave us an insightful session.
Thank you.
Thank you to all the participants watching us live, as well on the Facebook, as well as on YouTube. Thank you to all those, coupled with those who have been connected with us on the.
I'm grateful to all the brother and sister participants, sir. Thank you very much.
Mr. Ramachandran, we have already shared the WhatsApp link. You can connect with us on the Facebook of Beyond Law. You can connect with us for the previous webinars as well as the forthcoming webinars. Thank you.